Part 2. System of Government. 12 Parliamentary System. 13 Federal System. 14 Center-State Relations. 15 Interstate Relations. 16 Emergency Provisions. 12 Parliamentary System. The Constitution of India provides for a parliamentary form of government, both at the centre and in the states. Articles 74 and 75 deal with the parliamentary system at the centre and Articles 163 and 164 in the states. Modern democratic governments are classified into parliamentary and presidential on the basis of nature of relations between the executive and the legislative organs of the government. The parliamentary system of government is the one in which the executive is responsible to the legislature for its policies and acts. The presidential system of government, on the other hand, is one in which the executive is not responsible to the legislature for its policies and acts, and is constitutionally independent of the legislature in respect of its term of office. The parliamentary government is also known as cabinet government or responsible government or Westminster model of government and is prevalent in Britain, Japan, Canada, India among others. The presidential government, on the other hand, is also known as non-responsible or non-parliamentary or fixed executive system of government and is prevalent in USA, Brazil, Russia, Sri Lanka among others. Ivor Jennings called the parliamentary system as cabinet system because the cabinet is the nucleus of power in a parliamentary system. The parliamentary government is also known as responsible government as the cabinet, the real executive, is accountable to the Parliament and stays in office so long as it enjoys the latter's confidence. It is described as Westminster model of government after the location of the British Parliament, where the parliamentary system originated. In the past, the British constitutional and political experts described the Prime Minister as primus inter pares, first among equals, in relation to the cabinet. In the recent period, the Prime Minister's power, influence, and position have increased significantly vis-a-vis the cabinet. He has come to play a dominant role in the British politico-administrative system. Hence, the later political analysts, like Crossman, Mackintosh, and others have described the British system of government as prime ministerial government. The same description holds good in the Indian context too. Features of parliamentary government. The features or principles of parliamentary government in India are 1. Nominal and real executives. The President is the nominal executive, de jure executive or titular executive, while the Prime Minister is the real executive, de facto executive. Thus, the President is head of the state, while the Prime Minister is head of the government. Article 74 provides for a council of ministers headed by the Prime Minister to aid and advise the President in the exercise of his functions. The advice so tendered is binding on the President. 1. 2. Majority party rule. The political party which secures majority seats in the Lok Sabha forms the government. The leader of that party is appointed as the Prime Minister by the President, other ministers are appointed by the President on the advice of the Prime Minister. However, when no single party gets the majority, a coalition of parties may be invited by the President to form the government. 3. Collective responsibility. This is the bedrock principle of parliamentary government. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular, Article 75. They act as a team, and swim and sink together. The principle of collective responsibility implies that the Lok Sabha can remove the ministry, i.e., Council of Ministers headed by the Prime Minister, from office by passing a vote of no confidence. 4. Political homogeneity. Usually members of the Council of Ministers belong to the same political party, and hence they share the same political ideology. In case of coalition government, the ministers are bound by consensus. 5. Double membership. The ministers are members of both the legislature and the executive. This means that a person cannot be a minister without being a member of the Parliament. The Constitution stipulates that a minister who is not a member of the Parliament for a period of 6 consecutive months ceases to be a minister. 6. Leadership of the Prime Minister. The Prime Minister plays the leadership role in this system of government. He is the leader of Council of Ministers, leader of the Parliament and leader of the party in power. In these capacities, he plays a significant and highly crucial role in the functioning of the government. 7. Dissolution of the lower house. The lower house of the Parliament, Lok Sabha, can be dissolved by the President on recommendation of the Prime Minister. In other words, the Prime Minister can advise the President to dissolve the Lok Sabha before the expiry of its term and hold fresh elections. This means that the executive enjoys the right to get the legislature dissolved in a parliamentary system. 8. Secrecy. The ministers operate on the principle of secrecy of procedure and cannot divulge information about their proceedings, policies, and decisions. They take the oath of secrecy before entering their office. The oath of secrecy to the ministers is administered by the President. Features of presidential government. Unlike the Indian Constitution, the American Constitution provides for the presidential form of government. The features of the American presidential system of government are as follows. A. The American president is both the head of the state and the head of government. As the head of state, he occupies a ceremonial position. As the head of government, he leads the executive organ of government. B. The president is elected by an electoral college for a fixed tenure of 4 years. He cannot be removed by the Congress except by impeachment for a grave unconstitutional act. C. The President governs with the help of a cabinet or a smaller body called kitchen cabinet. It is only an advisory body and consists of non-elected departmental secretaries. They are selected and appointed by him, are responsible only to him, and can be removed by him any time. D. The President and his secretaries are not responsible to the Congress for their acts. They neither possess membership in the Congress nor attend its sessions. E. The President cannot dissolve the House of Representatives, the lower house of the Congress. F. The doctrine of separation of powers is the basis of the American presidential system. The legislative, executive, and judicial powers of the government are separated and vested in the 3 independent organs of the government. Merits of the parliamentary system. The parliamentary system of government has the following merits. 1. Harmony between legislature and executive. The greatest advantage of the parliamentary system is that it ensures harmonious relationship and cooperation between the legislative and executive organs of the government. The executive is a part of the legislature and both are interdependent at work. As a result, there is less scope for disputes and conflicts between the 2 organs. 2. Responsible government. By its very nature, the parliamentary system establishes a responsible government. The ministers are responsible to the Parliament for all their acts of omission and commission. The Parliament exercises control over the ministers through various devices like question hour, discussions, adjournment motion, no confidence motion, etc. 3. Prevents despotism. Under this system, the executive authority is vested in a group of individuals, council of ministers, and not in a single person. This dispersal of authority checks the dictatorial tendencies of the executive. Moreover, the executive is responsible to the Parliament and can be removed by a no-confidence motion. 4. Ready alternative government. In case the ruling party loses its majority, the head of the state can invite the opposition party to form the government. This means an alternative government can be formed without fresh elections. Hence, Dr. Jennings says, the leader of the opposition is the alternative prime minister. 5. Wide representation. In a parliamentary system, the executive consists of a group of individuals, i.e., ministers who are representatives of the people. Hence, it is possible to provide representation to all sections and regions in the government. The Prime Minister, while selecting his ministers, can take this factor into consideration. Demerits of the parliamentary system. In spite of the above merits, the parliamentary system suffers from the following demerits. 1. Unstable government. The parliamentary system does not provide a stable government. There is no guarantee that a government can survive its tenure. The ministers depend on the mercy of the majority legislators for their continuity and survival in office. A no-confidence motion or political defection or evils of multi-party coalition can make the government unstable. The government headed by Morarji Desai, Charan Singh, VP Singh, Chandrasekhar, Devagowda, and Ik Gujral are some such examples. 2. No continuity of policies. The parliamentary system is not conducive for the formulation and implementation of long-term policies. This is due to the uncertainty of the tenure of the government. A change in the ruling party is usually followed by changes in the policies of the government. For example, the Janata government headed by Morarji Desai in 1977 reversed a large number of policies of the previous Congress government. The same was repeated by the Congress government after it came back to power in 1980. 3. Dictatorship of the cabinet. When the ruling party enjoys absolute majority in the parliament, the cabinet becomes autocratic and exercises nearly unlimited powers. H. J. Lasky says that the parliamentary system gives the executive an opportunity for tyranny. Ramsay Muir, the former British Prime Minister, also complained of the dictatorship of the cabinet too. This phenomena was witnessed during the era of Indira Gandhi and Rajiv Gandhi. 4. Against separation of powers. In the parliamentary system, the legislature and the executive are together and inseparable. The cabinet acts as the leader of legislature as well as the executive. As Bajhat points out, the cabinet is a hyphen that joins the buckle that binds the executive and legislative departments together. Hence, the whole system of government goes against the letter and spirit of the theory of separation of powers. 3. In fact, there is a fusion of powers. 5. Government by amateurs. The parliamentary system is not conducive to administrative efficiency as the ministers are not experts in their fields. The Prime Minister has a limited choice in the selection of ministers, his choice is restricted to the members of Parliament alone and does not extend to external talent. Moreover, the ministers devote most of their time to parliamentary work, cabinet meetings, and party activities. Now, let us compare the parliamentary and presidential systems in terms of their features, merits, and demerits. Reasons for adopting parliamentary system. A plea was made in favor of U.S. presidential system of government in the Constituent Assembly 4. But, the Founding Fathers preferred the British parliamentary system due to the following reasons. Table 12.1 Comparing parliamentary and presidential systems. Parliamentary system. Presidential system. Features 1. Dual executive. Point 2. Majority party rule. 3. Collective responsibility. Point 4. Political homogeneity. 5. Double membership. Point 6. Leadership of Prime Minister. Point 7. Dissolution of Lower House. Point 8. Fusion of powers. Features 1. Single executive. Point 2. President and legislators elected separately for a fixed term. Point 3. Non-responsibility. 4. Political homogeneity may not exist. Point 5. Single membership. 6. Domination of President. Point 7. No dissolution of Lower House. Point 8. Separation of powers. Merits. 1. Harmony between legislature and executive. Point 2. Responsible government. Point 3. Prevents despotism. Point 4. Wide representation. Demerits. 1. Conflict between legislature and executive. Point 2. Non-responsible government. Point 3. May lead to autocracy. Point 4. Narrow representation. Demerits. 1. Unstable government. Point 2. No continuity of policies. Point 3. Against separation of powers. 4. Government by amateurs. Merits. 1. Stable government. Point 2. Definiteness in policies. Point 3. Based on separation of powers. Point 4. Government by experts. 1. Familiarity with the system. The constitution makers were somewhat familiar with the parliamentary system as it had been in operation in India during the British rule. K. M. Munshi argued that, for the last 30 or 40 years, some kind of responsibility has been introduced in the governance of this country. Our constitutional traditions have become parliamentary. After this experience, Why should we go back and buy a novel experience? 5. 2. Preference to more responsibility. Dr. B.R. Ambedkar pointed out in the Constituent Assembly that a democratic executive must satisfy two conditions, stability and responsibility. Unfortunately, it has not been possible so far to devise a system which can ensure both in equal degree. The American system gives more stability but less responsibility. The British system, on the other hand, gives more responsibility but less stability. The draft constitution in recommending the parliamentary system of executive has preferred more responsibility to more stability. 6. 3. Need to avoid legislative, executive conflicts. The framers of the Constitution wanted to avoid the conflicts between the legislature and the executive which are bound to occur in the presidential system prevalent in USA. They thought that an infant democracy could not afford to take the risk of a perpetual cleavage, feud, or conflict or threatened conflict between these two organs of the government. They wanted a form of government that would be conducive to the manifold development of the country. 4. Nature of Indian society. India is one of the most heterogeneous states and most complex plural societies in the world. Hence, the constitution makers adopted the parliamentary system as it offers greater scope for giving representation to various sections, interests, and regions in the government. This promotes a national spirit among the people and builds a united India. Whether the parliamentary system should be continued or should be replaced by the presidential system has been a point of discussion and debate in our country since the 1970s. This matter was considered in detail by the Swaran Singh Committee appointed by the Congress government in 1975. The committee opined that the parliamentary system has been doing well and hence, there is no need to replace it by the presidential system. Distinction between Indian and British models. The parliamentary system of government in India is largely based on the British parliamentary system. However, it never became a replica of the British system and differs in the following respects. 1. India has a republican system in place of British monarchical system. In other words, the head of the state in India, that is, President, is elected, while the head of the state in Britain, that is, King or Queen, enjoys a hereditary position. 2. The British system is based on the doctrine of the sovereignty of Parliament, while the Parliament is not supreme in India and enjoys limited and restricted powers due to a written constitution, federal system, judicial review, and fundamental rights. 7. 3. In Britain, the Prime Minister should be a member of the lower house, House of Commons, of the Parliament. In India, the Prime Minister may be a member of any of the two houses of Parliament. 8. 4. Usually, the members of Parliament alone are appointed as ministers in Britain. In India, a person who is not a member of Parliament can also be appointed as minister, but for a maximum period of 6 months. 5. Britain has the system of legal responsibility of the minister while India has no such system. Unlike in Britain, the ministers in India are not required to countersign the official acts of the head of the state. 6. Shadow Cabinet is an unique institution of the British cabinet system. It is formed by the opposition party to balance the ruling cabinet and to prepare its members for future ministerial office. There is no such institution in India. Notes and references. 1. The 42nd and 44th Amendment Acts of 1976 and 1978 respectively have made the ministerial advice binding on the President. 2. How Britain is Governed is a popular book written by him. 3. This theory was propounded by Montesquieu, a French political thinker, in his book The Spirit of Laws, 1748, to promote individual liberty. He stated that concentration of powers in one person or a body of persons would result in despotism and negate individual liberty. 4. K.T. Shah favored the adoption of the presidential system. 5. Constituent Assembly Debates, Volume 7, p. 284-5. 6. Constituent Assembly Debates, Volume 7, p. 32. 7. For details in this regard, see the section on the sovereignty of Parliament in Chapter 22. 8. For example, 3 Prime Ministers, Indira Gandhi, 1966, Dev Gupta, 1996, and Manmohan Singh, 2004, were members of the Rajya Sabha. 13 Federal system. Political scientists have classified governments into unitary and federal on the basis of the nature of relations between the national government and the regional governments. By definition, a unitary government is one in which all the powers are vested in the national government, and the regional governments, if at all exist, derive their authority from the national government. A federal government, on the other hand, is one in which powers are divided between the national government and the regional governments by the constitution itself, and both operate in their respective jurisdictions independently. Britain, France, Japan, China, Italy, Belgium, Norway, Sweden, Spain, and so on have the unitary model of government, while the US, Switzerland, Australia, Canada, Russia, Brazil, Argentina and so on have the federal model of government. In a federal model, the national government is known as the federal government or the central government or the union government, and the regional government is known as the state government or the provincial government. The specific features of the federal and unitary governments are mentioned below in a comparative manner. The term federation is derived from a Latin word foedus, which means treaty or agreement. Thus, a federation is a new state, political system, which is formed through a treaty or an agreement between the various units. The units of a federation are known by various names like states, as in US, or cantons, as in Switzerland, or provinces, as in Canada, or republics, as in Russia. Table 13.1 Comparing features of federal and unitary governments. Federal government. Unitary government. 1. Dual government, that is, national government and regional government. 1. Single government, that is, the national government which may create regional governments. 2. Written constitution. 2. Constitution may be written, France, or unwritten, Britain. 3. Division of powers between the national and regional government. 3. No division of powers. All powers are vested in the national government. 4. Supremacy of the Constitution. 4. Constitution may be supreme, Japan, or may not be supreme, Britain. 5. Rigid constitution. 5. Constitution may be rigid, France, or flexible, Britain. 6. Independent judiciary. 6. Judiciary may be independent or may not be independent. 7. Bicameral legislature. 7. Legislature may be bicameral, Britain, or unicameral, China. A federation can be formed in two ways, that is, by way of integration or by way of disintegration. In the first case, a number of militarily weak or economically backward states, independent, come together to form a big and a strong union, as for example, the US. In the second case, a big unitary state is converted into a federation by granting autonomy to the provinces to promote regional interest, for example, Canada. The US is the first and the oldest federation in the world. It was formed in 1787 following the American Revolution, 1775–83. It comprises 50 states, originally 13 states, and is taken as the model of federation. The Canadian Federation, comprising 10 provinces, originally 4 provinces, is also quite old, formed in 1867. The Constitution of India provides for a federal system of government in the country. The framers adopted the federal system due to two main reasons: the large size of the country and its socio-cultural diversity. They realized that the federal system not only ensures the efficient governance of the country but also reconciles national unity with regional autonomy. However, the term federation has nowhere been used in the Constitution. Instead, Article 1 of the Constitution describes India as a union of states. According to Dr. B.R. Ambedkar, the phrase union of states has been preferred to federation of states to indicate two things: I. The Indian Federation is not the result of an agreement among the states like the American Federation, and 2. The states have no right to secede from the federation. The federation is union because it is indestructible. Point 1. The Indian federal system is based on the Canadian model and not on the American model. The Canadian model differs fundamentally from the American model insofar as it establishes a very strong centre. The Indian Federation resembles the Canadian Federation, in its formation, i.e., by way of disintegration. 2. In its preference to the term union, the Canadian Federation is also called a union, and 3. In its centralising tendency, i.e., vesting more powers in the centre vis-a-vis the states. Federal features of the Constitution. The federal features of the Constitution of India are explained below. 1. Dual polity. The Constitution establishes a dual polity consisting the Union at the centre and the states at the periphery. Each is endowed with sovereign powers to be exercised in the field assigned to them respectively by the Constitution. The Union government deals with the matters of national importance like defense, foreign affairs, currency, communication, and so on. The state governments, on the other hand, look after the matters of regional and local importance like public order, agriculture, health, local government, and so on. 2. Written Constitution. The Constitution is not only a written document but also the lengthiest constitution of the world. Originally, it contained a preamble, 395 articles, divided into 22 parts, and 8 schedules. 2 At present, 2019, it consists of a preamble, about 470 articles, divided into 25 parts, and 12 schedules. 3 It specifies the structure, organization, powers, and functions of both the central and state governments and prescribes the limits within which they must operate. Thus, it avoids the misunderstandings and disagreements between the two. 3 Division of powers. The Constitution divided the powers between the centre and the states in terms of the Union list, state list, and concurrent list in the 7th schedule. The Union list consists of 98 subjects, originally 97, the state list 59 subjects, originally 66, and the concurrent list 52 subjects, originally 47. Both the centre and the states can make laws on the subjects of the concurrent list, but in case of a conflict, the central law prevails. The residuary subjects, i.e., which are not mentioned in any of the 3 lists, are given to the centre. 4 Supremacy of the Constitution. The Constitution is the supreme, or the highest, law of the land. The laws enacted by the centre and the states must conform to its provisions. Otherwise, they can be declared invalid by the Supreme Court or the High Courts through their power of judicial review. Thus, the organs of the government, legislative, executive, and judicial, at both the levels must operate within the jurisdiction prescribed by the Constitution. 5 Rigid Constitution. The division of powers established by the Constitution as well as the supremacy of the Constitution can be maintained only if the method of its amendment is rigid. Hence, the Constitution is rigid to the extent that those provisions which are concerned with the federal structure, i.e., centre-state relations and judicial organization, can be amended only by the joint action of the central and state governments. Such provisions require for their amendment a special majority of the Parliament and also an approval of half of the state legislatures. 6 Independent Judiciary. The Constitution establishes an independent judiciary headed by the Supreme Court for 2 purposes: 1. To protect the supremacy of the Constitution by exercising the power of judicial review, and 2. To settle the disputes between the centre and the states or between the states. The Constitution contains various measures like security of tenure to judges, fixed service conditions and so on to make the judiciary independent of the government. 7 Bicameralism. The Constitution provides for a bicameral legislature consisting of an upper house, Rajya Sabha, and a lower house, Lok Sabha. The Rajya Sabha represents the states of Indian Federation, while the Lok Sabha represents the people of India as a whole. The Rajya Sabha, even though a less powerful chamber, is required to maintain the federal equilibrium by protecting the interests of the states against the undue interference of the centre. Unitary features of the Constitution. Besides the above federal features, the Indian Constitution also possesses the following unitary or non-federal features. 1 Strong centre. the division of powers is in favor of the center and highly inequitable from the federal angle. Firstly, the Union list contains more subjects than the state list. Secondly, the more important subjects have been included in the Union list. Thirdly, the center has overriding authority over the concurrent list. Finally, the residuary powers have also been left with the center, while in the U.S., they are vested in the states. Thus, the Constitution has made the center very strong. 2 states not indestructible. Unlike in other federations, the states in India have no right to territorial integrity. The Parliament can by unilateral action change the area, boundaries, or name of any state. Moreover, it requires only a simple majority and not a special majority. Hence, the Indian Federation is an indestructible union of destructible states. The American Federation, on the other hand, is described as an indestructible union of indestructible states. 3. Single constitution. Usually, in a federation, the states have the right to frame their own constitution separate from that of the center. In India, on the contrary, no such power is given to the states. The Constitution of India embodies not only the constitution of the center but also those of the states. Both the center and the states must operate within this single frame. The only exception in this regard was the case of Jammu and Kashmir, which had its own state constitution. 5. 4. Flexibility of the Constitution. The process of constitutional amendment is less rigid than what is found in other federations. The bulk of the Constitution can be amended by the unilateral action of the Parliament, either by simple majority or by special majority. Further, the power to initiate an amendment to the Constitution lies only with the center. In U.S., the states can also propose an amendment to the Constitution. 5. No equality of state representation. The states are given representation in the Rajya Sabha on the basis of population. Hence, the membership varies from 1 to 31. In U.S., on the other hand, the principle of equality of representation of states in the upper house is fully recognized. Thus, the American Senate has 100 members, 2 from each state. This principle is regarded as a safeguard for smaller states. 6. Emergency provisions. The Constitution stipulates 3 types of emergencies: national, state and financial. During an emergency, the central government becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation is not found in any other federation. 7. Single citizenship. In spite of a dual polity, the Constitution of India, like that of Canada, adopted the system of single citizenship. There is only Indian citizenship and no separate state citizenship. All citizens irrespective of the state in which they are born or reside enjoy the same rights all over the country. The other federal states like US, Switzerland and Australia have dual citizenship, that is, national citizenship as well as state citizenship. 8. Integrated Judiciary. The Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the state high courts below it. This single system of courts enforces both the central laws as well as the state laws. In US, on the other hand, there is a double system of courts whereby the federal laws are enforced by the federal judiciary and the state laws by the state judiciary. 9. All India services. In US, the federal government and the state governments have their separate public services. In India also, the center and the states have their separate public services. But, in addition, there are all India services, IS, IPS, and IPS, which are common to both the center and the states. The members of these services are recruited and trained by the center, which also possess ultimate control over them. Thus, these services violate the principle of federalism under the Constitution. 10. Integrated audit machinery. The Controller and Auditor General of India audits the accounts of not only the central government but also those of the states. But, his appointment and removal is done by the President without consulting the states. Hence, This office restricts the financial autonomy of the states. The American Comptroller General, on the contrary, has no role with respect to the accounts of the states. 11. Parliament's authority over state list. Even in the limited sphere of authority allotted to them, the states do not have exclusive control. The Parliament is empowered to legislate on any subject of the state list if Rajya Sabha passes a resolution to that effect in the national interest. This means that the legislative competence of the Parliament can be extended without amending the Constitution. Notably, this can be done when there is no emergency of any kind. 12. Appointment of Governor. The Governor, who is the head of the state, is appointed by the President. He holds office during the pleasure of the President. He also acts as an agent of the center. Through him, the center exercises control over the states. The American Constitution, on the contrary, provided for an elected head in the states. In this respect, India adopted the Canadian system. 13. Integrated election machinery. The Election Commission conducts elections not only to the central legislature but also to the state legislatures. But, this body is constituted by the President and the states have no say in this matter. The position is same with regard to the removal of its members as well. On the other hand, U.S. has separate machineries for the conduct of elections at the federal and state levels. 14. Veto over state bills. The governor is empowered to reserve certain types of bills passed by the state legislature for the consideration of the president. The president can withhold his assent to such bills not only in the first instance but also in the second instance. Thus, the president enjoys absolute veto, and not suspensive veto, over state bills. But in US and Australia, the states are autonomous within their fields and there is no provision for any such reservation. Critical evaluation of the federal system. From the above, it is clear that the Constitution of India has deviated from the traditional federal systems like US, Switzerland and Australia and incorporated a large number of unitary or non-federal features, tilting the balance of power in favor of the center. This has prompted the constitutional experts to challenge the federal character of the Indian Constitution. Thus, K.C. Weir described the Constitution of India as quasi-federal. He remarked that Indian Union is a unitary state with subsidiary federal features rather than a federal state with subsidiary unitary features. 6. According to K. Santhanam, the two factors have been responsible for increasing the unitary bias, tendency of centralization, of the Constitution. These are, I. The dominance of the center in the financial sphere and the dependence of the states upon the central grants, and, 2. The emergence of a powerful erstwhile planning commission which controlled the developmental process in the states. 6a. He observed, India has practically functioned as a unitary state though the Union and the states have tried to function formally and legally as a federation. 7. However, there are other political scientists who do not agree with the above descriptions. Thus, Paul Appleby 8 characterizes the Indian system as extremely federal. Morris Jones 9 termed it as a bargaining federalism. Ivor Jennings 10 has described it as a federation with a strong centralizing tendency. He observed that the Indian Constitution is mainly federal with unique safeguards for enforcing national unity and growth. Alexandros 11 stated that India is a case sui generis, i.e., unique in character. Granville Austin 12 called the Indian federalism as a cooperative federalism. He said that though the Constitution of India has created a strong central government, it has not made the state governments weak and has not reduced them to the level of administrative agencies for the execution of policies of the central government. He described the Indian Federation as a new kind of federation to meet India's peculiar needs. On the nature of Indian Constitution, Dr. B.R. Ambedkar made the following observation in the Constituent Assembly: the Constitution is a federal constitution in as much as it establishes a dual polity. The Union is not a league of states, united in a loose relationship, nor are the states the agencies of the Union, deriving powers from it. Both the Union and the states are created by the Constitution, both derive their respective authority from the Constitution. 13. He further observed, Yet the constitution avoids the tight mold of federalism and could be both unitary as well as federal according to the requirements of time and circumstances. Point 14. While replying to the criticism of over-centralization in the constitution, he stated, "A serious complaint is made on the ground that there is too much centralization and the states have been reduced to municipalities. It is clear that this view is not only an exaggeration but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relations between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principle of federalism is that the legislative and executive authority is partitioned between the center and the states not by any law to be made by the center but by the Constitution itself. This is what the Constitution does. The states are in no way dependent upon the center for their legislative or executive authority. The states and the center are co-equal in this matter. It is difficult to see how such a constitution can be called centralism. It is, therefore, wrong to say that the states have been placed under the center. The center cannot by its own will alter the boundary of this partition. Nor can the judiciary. Point 15. In Bicameralism 16, 1994, the Supreme Court laid down that the Constitution is federal and characterized federalism as its basic feature. It observed, "The fact that under the scheme of our Constitution, greater power is conferred upon the center vis-a-vis the states does not mean that the states are mere appendages of the center. The states have an independent constitutional existence. They are not satellites or agents of the center. Within the sphere allotted to them, the states are supreme. The fact that during emergency and in certain other eventualities their powers are overridden or invaded by the center is not destructive of the essential federal feature of the Constitution. They are exceptions and the exceptions are not a rule. Let it be said that the federalism in the Indian Constitution is not a matter of administrative convenience, but one of principle, the outcome of our own process and a recognition of the ground realities. In fact, the federalism in India represents a compromise between the following two conflicting considerations. 17. I. Normal division of powers under which states enjoy autonomy within their own spheres, and 2. Need for national integrity and a strong union government under exceptional circumstances. The following trends in the working of Indian political system reflects its federal spirit. I. Territorial disputes between states, for example, between Maharashtra and Karnataka over Belgaum. 2. Disputes between states over sharing of river water, for example, between Karnataka and Tamil Nadu over Kaveri water. 3. The emergence of regional parties and their coming to power in states like Andhra Pradesh, Tamil Nadu, etc. 4. The creation of new states to fulfill the regional aspirations. For example, Mizoram or Jharkhand. v. Demand of the states for more financial grants from the center to meet their developmental needs. 6. Assertion of autonomy by the states and their resistance to the interference from the center. 7. Supreme Court's imposition of several procedural limitations on the use of Article 356, President's rule in the states, by the center. 18. Notes and references. 1 Constituent Assembly Debates, Volume 7, p. 43. 2 The American Constitution originally consisted only 7 articles, the Australian 128 and the Canadian 147. 3 The various amendments carried out since 1951 have deleted about 20 articles and 1 part, 7, and added about 95 articles, 4 parts, EVA, IXA, IXB, and XIBA, and 4 schedules, 9, 10, 11 and 12. 4 A majority of 2/3 of the members of each house present and voting and a majority of the total membership of each house. 5 Till 2019, the erstwhile state of Jammu and Kashmir enjoyed a special status by virtue of Article 370 of the Constitution of India. 6 K.C. Weir, Federal Government, 1951, p. 28. 6a In 2015, the Planning Commission was replaced by a new body called NITI, National Institution for Transforming India. 7 K. Santhanam, Union-State Relations in India, 1960, pages 50 to 70. 8. Paul Appleby, Public Administration in India, 1953, p. 51. 9. Morris Jones, The Government and Politics in India, 1960, p. 14. 10. Ivor Jennings, Some Characteristics of the Indian Constitution, 1953, p. 1. 11. C. H. Alexandroas, Constitutional Development in India, 1957, pages 157 to 70. 12. Granville Austin, The Indian Constitution, Cornerstone of a Nation, Oxford, 1966, pages 186 to 88. 13. Constituent Assembly Debates, Volume 8, p. 33. 14. Ibid, Volume 7, pages 33 to 34. 15. Dr. B. R. Ambedkar's speech in the Constituent Assembly on 25.11.1949 reproduced in the Constitution and the Constituent Assembly, Lok Sabha Secretariat, 1990, p. 176. 16. S. R. Bommai v. Union of India, 1994. 17. Subhash C. Kashyap, Our Parliament, National Book Trust, 1999 edition, p. 40. 18. S. R. Bommai v. Union of India, 1994. For the details of the judgment, see President's Rule in Chapter 16. 14. Centre-State Relations. The Constitution of India, being federal in structure, divides all powers, legislative, executive, and financial, between the centre and the states. However, there is no division of judicial power as the Constitution has established an integrated judicial system to enforce both the central laws as well as state laws. Though the centre and the states are supreme in their respective fields, the maximum harmony and coordination between them is essential for the effective operation of the federal system. Hence, the Constitution contains elaborate provisions to regulate the various dimensions of the relations between the centre and the states. The centre-state relations can be studied under three heads: legislative relations, administrative relations, financial relations. Legislative relations. Articles 245 to 255 in Part 11 of the Constitution deal with the legislative relations between the centre and the states. Besides these, there are some other articles dealing with the same subject. Like any other federal constitution, the Indian Constitution also divides the legislative powers between the centre and the states with respect to both the territory and the subjects of legislation. Further, the Constitution provides for the parliamentary legislation in the state field under 5 extraordinary situations as well as the centre's control over state legislation in certain cases. Thus, there are 4 aspects in the centre-states legislative relations, viz. Territorial extent of central and state legislation. Distribution of legislative subjects. Parliamentary legislation in the state field.